members of the committee. My name is Brian Burdick. I'm a partner with Barnes & Thornburg law firm here in Indianapolis, and I represent the United States Small Business Owners Association. That is a trade association of 900 independent owner-operators of gas station and convenience stores here in Indiana. First of all, I do think it's fair to break this bill down into two distinct parts. One deals with eligible party and the definition of an eligible party. The second is this information around all these additional powers that they need, that they already possess, under the guise of they need to help out on the financially enforce these rules that they have today. So I will speak to the bill here in a second, but let me just tell you real specifically what this is all about, okay, and make no bones about it. Right? This is an effort that changes the definition of eligible party, that strips the members, and I have several members here today, folks here, that own these facilities here in the audience today, that strips their property right, strips the value of their property. The ELF fund and the statute clearly states, and you can see on the bottom of page 1, look at lines 11, the definition of eligible party, and we'll walk through what's being changed, but you'll notice that current law says owner, this is an eligible party. 2, operator. 3, a former owner or operator, so you presume 1 and 2 mean current, I would, in the previous ones. And then a transferee of property on which a UST is located, and transferee on property which UST was located, which has been removed. Now that is very, very different. That's a different definition than responsible party. So there's two concepts in the ELF statute that's really important. Financially responsible. Eligible party is much broader than that. Okay? Financially responsible party means to the third party liability, to the neighbor next door. If the gas and the benzene gets in there, they're stuck paying it. They have insurance for that. I heard them say they don't have rights of subrogation. Senator Sandlin, you're right on that. I think former Attorney General Zeller will speak to that. But eligible party, so that has to do with financial liability to third parties. Separate and distinct from that, you have eligible party to clean up the property. That is any successive owner. Okay? These things 20 years ago, right? And the current owner. 20 years ago, let's say Sunoco owned a property, right? And it leaked. They are the financially responsible party. And they sold it to me, and then I sold it to Senator Buck, and then Senator Messmer, and so on, and now my client has it. Each of these people is an eligible party to clean the ground up. The policy behind that is whenever somebody here has the gumption to clean this dirty stuff up out of the ground, do it, and we'll reimburse you for those expenses. That's part of the fund's purpose, the stated statutory purpose. That doesn't relieve this person's liability. It does mitigate their damages. I mean, that would have just continued to grow if they left it in the ground. But let's not act for a moment like this person is some sympathetic person whose rights have been abridged by the current owner cleaning up the property. For 20 years, they didn't clean it up. And they could have. I mean, I don't think they sat there and said, man, today's the day the alarm went off. 20 years in a day. Man, we're going to clean that thing up today. I've been waiting for it. It's not what happens out there. My guys own and buy typically older stations. They don't build new stations. Okay? They tend to have those tanks underground. They want to clean those properties up, and they do it. So if you look at what's done in the first section here, eligible party definition has been changed to make it the financially responsible party. It says, if you're the owner, look at 1 now, is eligible party, a person who was an owner when the release from the UST occurred. I mean, this is substantial. You might as well just cross-reference a responsible party as a name for eligible party. That takes my guys out of the game. But unless, IDEM has said, unless you take on their financial liability. Who would do that? Okay, in their right mind. This is designed to stop land transactions. Okay? Oh, and then it says in the last section of the bill, but if you can't identify them, you can agree an agreed order with IDEM to take on that person's financial responsibility. Again, who would do that? The purpose of this is to control the ELF fund. I would agree with that. They want to make sure they do it. But it's not by some hocus pocus saying we need this additional law about fraud, waste, and abuse, etc. They have the authority to do these things, and I'll point to that in current law. It's to limit who can actually be an eligible party, and limit it only to those financially responsible parties. Those would be the people that have chosen not to do it for 20 years. Again, I don't think that it's going to happen tomorrow. So let's talk real specifically, because I don't want this to be missed. By the way, we've been dealing with this with IDEM for about 15 months. They changed their law. This is the way they interpret it today. You talk about the four corners of the document. My goodness, it couldn't be any more clear. Owner, operator, previous owner, operator, and then and transferees of those property. Now they're changing it to say not any of those guys, just the person with the financial liability. I mean, gosh, this bill in and of itself is a statement against interest that they've been violating the law and how they've applied it. They're baiting people into litigation. We've tried to resolve it together, meeting with them. It's an impasse. There's no chance to it. But they are taking my guys' rights, my independent owner-operator rights. This is just a misdirection play about what's going on. They're going to control the cost by taking my guys' rights and saying the only person that you have to take their liability on, which no sane human would do, or you have to be this person who has chosen for 20 years to not do it. That's how they're going to protect the fund.
2. Seek to clarify the definition of eligible party. The current definition has been used to argue that any property owner at any time can have access to the fund. We want to make sure it's clear that the purposes for making a claim, you have to be the responsible party for the contamination, or have the assignment of rights to do so. For a long time, IDEM has been asleep at the wheel. We assumed that when property transactions were taking place, that those transactions were including the liability or the assignment of rights. We were not checking to make sure that this was accurate, that we don't have that specific authority. So we want to make sure it's clear we have that specific authority.
Okay. I would say it'd be more of a mandate that you do your job.
Exactly.
Where'd you come up with $1 million on the third party indemnification? I mean, how do we have any idea
So we
that
took,
that's neat? I mean,
right.
we
So
need documents.
we took what other states have done, and there is a sheet in here that shows how different states have split up their cap, and we mimicked that.
All right, but it's not based on any documents or
No.
actuality from what's going on in the state of Indiana.
Correct.
And I'll say, if we're worried about the fund, take a quick look at the fiscal impact statement. It makes it clear that nothing in this bill protects the fund. In fact, it says, I have to take off my glasses, the provision could potentially increase the number of claims and reduce the funds available in the ELF. So in fact, it doesn't protect the fund, which I think everybody needs to, this would be a perfect summer study. Let's talk about how to protect this fund. Everybody should agree that that's a priority. To reiterate what Brian said, IDEM did change the eligibility definition back in February. This is the 1-year anniversary. So instead of doing cleanups, we've been doing paperwork. We now, instead of going out and remediating, we're trying to comply with these new requirements that the current owner, which we always assumed was the party who would be eligible, they're the ones who get you on the property. They're the ones who are running a business. They want to make sure you don't tear up their driveway or their entranceway. So they have a legitimate interest in protecting their property. They were told at the time, and in my previous role, I would have not liked to have heard the agencies say we were asleep at the wheel. But all the decades that they were asleep at the wheel, these property owners were told that when you buy this, you're going to be in charge of the cleanup. We always worked with the guy on the ground, get access, where do you put the trucks, where are you going to drill? So all these things are really property rights that, again, I agree, they were asleep at the wheel. If they wanted to do this, they may have had an opportunity 25 years ago when they should have said only the liable party and not the current owner. But we've gone down this path, and now these people, I think, really have a right to say, this is my property, I want to control what goes on. Finally, this eligibility issue is before Judge Gibbs. I was there on Friday. I think the attorney for IDEM was there. Quite frankly, I think Judge Gibbs, who knows a lot about the ELF fund, I never predict how a judge will rule, but I would like to wait and see. And I suspect if you wait, you'll find that the property rights of the owners that the statute says are eligible parties under today's definition, as the Attorney General's opinion states. So